that.
Thank you, I mean. And do you still have some pending files there, Haja?
It's like everything is in you now. So send them because who brought some?
Okay. Okay, we don't have any pending case in Lagos.
No. Even that of Francis.
Francis, yes.
And everything. I gave the process to.
Yes, I saw them.
So
I saw them.
The Lordship just hear them to add.
Yes, he's applying to amend his pleadings, but
yes, my Lord.
At this point of the proceedings.
And my Lord, even at judgment, they can decide to amend.
Yes, but the thing is that because of this issue of maybe I don't know whether he may need to recall the. He may need to recall the.
My Lord, claimant counsel for today is also claimant counsel for that matter, so they can swear if after the judgment.
Yes, that's
address that.
Mr. Paul Ba.
Yes, my Lord.
Mr. Paul, I didn't see him. Has he joined?
His colleague has joined, Stephen.
Stephanie. Okay, Stephanie. And okay, have they joined? All of them joined?
Everyone, including the defendant counsel.
But I didn't see them.
Good morning, my lord. Good morning, Stephanie, my lord.
Good morning. How are you? Well done. Yes, Stephanie.
The defendant counsel too is there.
Okay, it's there.
They sent them link before, but the link has no time. They were not asking me.
Yes.
My own link.
Yes. You know, Fatai can do that.
So many things to do at the same time. That's why you can forget for sometimes.
Okay. I see. Yes, there was no time. So how is Lagos? How are you faring?
Lagos, now money will not
maybe they're going to pay you 13 months salary, or something.
Well, don't put probability, or just be sure that they are going to pay us. We'll be glad to receive it, though. 13 months. We never received one before.
But anyway, I don't know. we should continue praying, isn't it?
Yes. God will grant them the energy and power to do
yes
as many as what they are praying they want to do.
Yes, and to this thing to think about you.
Yes, my Lord. So let them
yes, to remember you.
Yes, to remember us registrars. My Lord, we are the public eye. We are their eye in the court. Because whatever we do, it will affect the...
Yes, really.
So
really, you're trying your best.
The registrars and all of us, not only in Lagos, but everywhere.
You are the engine room now. Without you, can the court sit? The court can't sit now.
We made mistake. The mistake will affect the whole court.
Yes, and without you, nothing can happen now, isn't it? Yes, without registry.
Well, we should
how can he just conduct his cases? How can he do his cases? How can he sit? So
they should try and consider us registrars too.
But the minimum wage has been implemented, but
it never complete.
Okay. Maybe they are still owing you some arrears, go.
Yes, and the promise of what the CBN.
But I think one thing is that even the 2025 budget is not fully implemented. It's not fully implemented. The judiciary is still receiving the allocation of 2024. Still receiving the allocation of 2024. And I think that they're even going to extend the implementation of the 2025 budget to next year. I think they will do that. Okay, so let me deliver this judgment.
Let me mute myself so that I'm not affected. I want to mute myself so that it will not affect your worship.
Okay. Should I read everything, because it seems it's a lengthy something? Okay, but let me record the. So Clement, parties absent, ba?
In fact, the claimant is online.
Okay, it's online. Okay, the claimant is online.
Yes, my love. Stephanie, is he online? Stephanie does his phone.
Is Mr. Emmanuel Jeffrey?
My Lord, I'm present. I'm appearing with my colleague, Eunice Adekule.
Okay, just hold on, please. Stephanie.
Sorry, my lord, my network threw me out.
Huh?
Sorry, my lord, this is Stephanie Ukonga.
Yes.
I'm here for the claimants, my lord.
Okay, thank you. You said the claimant is online? Stephanie?
Yes, my lord. Yes, the claimant is present.
Okay.
Government of the state government. So I'm attending it with the Eunice.
So Mr. Jeffrey, you appear with who?
With Eunice Adekule.
Eh?
With Eunice Adekule.
Yunus or what?
Eunice Adekule.
I didn't get this name, please.
Eunice Adekule.
Okay, can you spell it, please?
Okay, Eunice spelled as EUNICE. EUNICE.
EUNICE. Adekule.
Yes, my lord.
For the defendant.
Yes, my lord.
Thank you. So this is my judgment. This is a case of alleged unlawful dismissal of the claimant from the defendant's employment, which was commenced by a complaint and other accompanying processes dated 18 December 2018, but filed on the 19 December 2018, while the claimant asked for certain reliefs and contained in his statement of facts against the defendant. The defendant, in reaction to the claimant's filed processes on to apply to the defendant's statement of defense. The fact giving rise to the case of the claimant is that he was employed as a senior clerk on the 16th of August 1990 and rose through the ranks to the position of a senior manager before his unlawful dismissal from his employment by the defendant. Claimant averred that due to diligence in the performance of his duties, he was promoted several times from senior clerk to senior manager. Claimant also averred that on 5th January 2017 at about 7:30 p.m. on his way to office, he was involved in a road traffic accident along Apongo Road, Lagos. Claimant also averred that on 5th January 2017 at about 7:30 p.m. on his way to office, he was involved in a road accident along Apongo Road, Lagos, and was taken to a nearby clinic. That in the morning of 6th January 2017, he went to the defendant's clinic at Satellite Town, Lagos, where he was further referred to ML Hospital for X-ray, evaluation, treatment, and management. That the ML Hospital sent a report on 6th of January 2017, which indicated that the claimant had an open compound fracture and recommended surgery at a cost of 635,000 naira. But the defendant did not give approval to the request for the surgery expenditure until 2nd February 2017. However, the said approval was never communicated to him, hence he wrote to the defendant on 6th April 2017 to seek treatment from traditional bone setters. Claimant averred that the approval of the surgery expenditure was only made known to him in July 2017. Claimant stated that the defendant gave him sick leave for 2 weeks on 6th of January 2017, and on 18th of January 2017, while he was on sick leave, he was transferred to Calabar. But he wrote on 2nd February 2017 for a reversal of the transfer in view of his poor state of health. That his transfer was eventually cancelled on 28th March 2017. That following the non-receipt of approval sent by email hospital on 26 January 2017, claimant went to Abuja in March 2017 and to see the Director of Human Resources Department. It is also the case of the claimant that when he reported for duty on 5th February 2018, his head of department told the manager and senior manager of the department not to mark him present. That on 5th March 2018, the claimant was issued a query, and on 8th March 2018, he was served with a letter of indefinite suspension. Claimant also stated that on 11th of April 2018, he was invited to a central disciplinary committee on alleged prolonged absence from work and eventually dismissed. It is the contention of the claimant that his long absence from duty was known to the defendant and that his dismissal was unlawful and in breach of his contract of employment. Trial in this case commenced on 14th October 2021, where the claimant in proof of his case testified and adopted his witness statement on oath dated 19/12/2018 and a further witness statement on oath dated 10th November 2021 and tendered in evidence exhibits CU1 to CU25. CW1 was cross-examined as there was no re-examination. The case of the claimant was closed. From the part of the defendant, our case is, however, that the claimant was her employee. As a result of his prolonged absence from duty, he was issued queries which he responded that he was further invited to the Central Disciplinary Committee and present throughout the proceedings of the CDS and allowed to defend himself and afforded fair hearing on the allegations against him. That the claimant fully participated in the CDC process, after which a report was issued recommending the claimant dismissal. Defendant about that the claimant was invited to the Employment Relations Office of the HRD to explain his absence from duty for over a year, and his excuse was that he was receiving treatment, and his excuse that he was receiving treatment was not good enough to warrant his absence from work for a year without appropriate medical cover. The Deputy Director HRD of the defendant, Mrs. Mercy Ekezi, explained this to the CDC in a testimony as shown on page 48 of the report of the CDC. Defendant also averred that the Medical Services Department of the defendant, as represented by Dr. Ojumu, confirmed the claimant's status of health and concluded that the refusal of the claimant to be treated by an orthopedic surgeon or return to work amounted to malingering, which is a misconduct under the defendant's policies and procedures manual. Defendant contended that the claimant failed and neglected to report for duty before or after the cancellation of his transfer to Calabar, and indeed was absent from duty or abandoned his duty without lawful permission from February 13, 2017 to February 5, 2018, which is a period of about 223 working days. Defendant also contended that the claimant is not entitled to the declaration and order sought in his statement of fact. The claimant dismissal from the defendant employment followed due process and comply with the applicable employment terms and conditions between the claimant and the defendant. The defendant in presenting his defense on 17 March 2022 called Tolulope Shole, DW1, who adopted his written statement on oath dated 21st May 2019 and tendered was cross-examined and then re-examined and thereafter discharged. Bashir Abdullah Ibrahim, DW2, who adopted his written statement on oath dated 21st and CBN 4A to C. The case of the defendant was then closed, and the matter was adjourned for adoption of final written addresses. Defendant's final written address. Defendant filed his final written address on 16th of December 2022, where, whether having regard to the evidence led at trial, the claimant has made out a case to be entitled to the relief sought against the defendant in this suit. The counsel submitted that in an action for wrongful dismissal from employment, the burden is always on the claimant to prove the terms and conditions of the contract of employment and in what manner the said terms were breached by the employer. It's also well established that actions for wrongful dismissal are founded on the terms of the contract for employment, which terms must be pleaded and proved by the claimant. The court of law would not venture beyond the confines of the contract in search of greener conditions to favor one of the parties. Counsel rely on the case of NNPC and Jacobs. Furthermore, counsel admitted that the courts have held that where a claimant alleges that his dismissal is wrongful, his dismissal is wrongful, the court is expected to look out for whether the dismissal was in accordance with the terms of his employment. And secondly, whether the principle of od ultra partem, which imposes a duty on the employer to act fairly, was observed. Counsel cited the case of CCE Nigeria Limited and Igila, Imonike, and Unity Bank PLC. Counsel contended that in the instance case, the claimant was absent from work for a period of about 2 to 3 working days, and section 6.4.2.2 sub B of the defendant's Human Resources Policies and Procedures Manual provides that prolonged absence from duty for a period of 30 days or more without permission constitutes gross misconduct for which summary dismissal is the appropriate penalty. That, as stated earlier, queries were issued to the claimant in accordance with sections 6.4.3 and 6.5.4 of Exhibit SU3, to which the claimant responded via Exhibit CBN2 and Exhibit CSU12. Furthermore, the claimant was invited to the Central Disciplinary Committee, where he was present throughout the proceedings of the CDC and was allowed to defend himself on allegations of misconduct against him. That the action taken as a result of the CDC's proceedings was communicated to the claimant via a letter of dismissal dated 17 September 2018. To the contention of counsel that from the foregoing, the defendant has fully complied with the tenets of natural justice as enshrined by the Nigerian courts. Counsel referred to the case of Yemisi and FIRS. It is the further contention of counsel that where an employee is issued a query and the said employee answers it before a decision is taken, the employer is said to have satisfied the requirements of fair hearing or natural justice. Counsel referred to the case of Monike and Unity Bank Supra. The other counsel submitted that the task before the Honorable Court is simple and straightforward, that it is the claimant's responsibility to prove that his dismissal from the defendant was wrongful, and it's not for the court to guess or speculate on the claimant's claim. Counsel referred to the case of Ekenta-based Nigeria Limited and River State, where it was held that speculation has no place in our courts, that with the claimant failing to decide his burden of proof, the only option available to this court is to dismiss the entirety of the claimant's claims. Counsel also referred to the case of Imonike and Unity Bank. Counsel contended that the claimant has alleged that his suspension from the defendant was unlawful. However, he has failed to state what aspect of the said suspension is unlawful. Counsel maintained that all the arguments relating to suspension of the claimant are irrelevant, and as they cannot be linked to any of the relief's claim. At a glance at paragraph 31 on pages 8 to 9 of the statement of facts shows that the claimant has not sought any declaratory or monetary relief regarding his suspension. Counsel referred to the case of Jankada and Olurutomba, where it was held that parties are bound by the reliefs as framed, and it's not the duty of the court to grant any relief outside what has been claimed. That based on the arguments above, counsel urged the court to dismiss reliefs A, B, C, D, F, and H of the statement of facts for lacking in merit. Regarding relief G, counsel stated that the claimant is not entitled to reinstatement as he has failed to prove that his dismissal was unlawful. Furthermore, the claimant's alternative reliefs under sections 14.3 and 16.3.2 of Exhibit SU3, talking about invalidation and overview, must also fail. The counsel argued that the claimant was never considered as an invalid on health or any other acceptable ground under section 14.3, and the claimant did not resign, die in service, or retire from the defendant to be entitled to end of service benefits as contemplated under section 16.3.2 of Exhibit 3. As to reliefs I, counsel further argued that the claimant has failed to prove his entitlement to medical expenses and health insurance. That it is in evidence before the Honorable Court that the sum of 585,000 naira was approved for the claimant's surgery, and upon becoming aware of the approval, the claimant refused to present himself for the surgery. That the claimant has also failed to provide evidence in proof of reliefs J, K, and I, and counsel therefore urged the court to dismiss the entirety of the claim for being an abuse of court process, lacking in merit. Claimant's final written address. Claimant's filed his final written address on 30th January 2023, wherein his counsel submitted the following issues for termination to it. Number one, whether dismissal of the claimant according with his contract of employment, the Human Resources Policy and Procedure Manual, and the CBN Act. Whether the claimant is entitled to all his other reliefs in this suit. Number one, reinstatement of the claimant. Number two, payment of claimant's productivity allowance for 2017 allowance withheld by the defendant. Number C, payment of the medical expenses incurred by the defendant. Number D, compensation in the sum of 1 billion naira pursuant to Section 19 of the National Industrial Court Act. Number E, cost of the action. On issue one, counsel submitted that the dismissal of the claimant did not accord with his contract of employment, the Human Resources Policy and Procedures Manual, and the CBN Act. That the letter of dismissal indicated that the claimant was dismissed for gross misconduct. However, paragraph 5 of the defendant's statement of defense indicated that the claimant was issued queries and invited to the CDC on allegation of prolonged absence from duty. And the claimant was also queried for disclosure of official information without authority. Counsel submitted that the evidence before this court indicated via exhibits SC 4A, 5, 6, 7, 14A to K, 17, 18, 19, 22A and B, and 23A to C. The defendant was well aware of the medical condition of the claimant. The defendant in paragraphs 12 and 13 of his statement of defense admitted that it booked the claimant for 2017 annual leave, while the facts indicated that he was not in the office due to illness. The contention that it was the duty of the claimant who was on sick leave to apply and obtain an extension of medical leave is not sustainable. Council referred to section 5.3.3.1 of Exhibit 3 at page 28, which provides those, and I quote, if absence for extended period, the administrator/line manager must forward a form to the house address of the staff for immediate completion and return to the bank. Council first submitted that there is no evidence that sick leave extension was forwarded to the home address of the claimant by the defendant. Just submitted that the defendant was sent a request for surgery on the claimant by a letter dated 28 February 2017 by ML Hospital, but the defendant only gave approval in July 2017. This submission of counsel that section 5.3.2 of the defendant's manual at page 27 to 28 under the subheading I quote medical certificates provides that absence claimed as sick leave must be covered by medical certificate. Counsel submitted that the defendant was given medical certificates of the claimant and paid the claimant's salary as seen in the claimant's payslip. Lana counsel contended that the alleged prolonged absence from work was an agenda by the defendant through the claimant's head of department, Mr. Tobatele, who instructed that the claimant should not be marked present when he reported to work. Submission of counsel that even though the defendant accused the claimant of malingering and failure to report to work between 13 February 2017 and 5th February 2018, however, counsel submitted that it is in evidence before the court that the claimant continued to report to work, though his attendance was not reflected in the staff position, and the medical certificate issued to the claimant and sent to the defendant, of which dates of issuance was within the period of the claimant was alleged to be out of office. Counsel submitted that it is state law that where there is a specific provision to guide a matter, it should be restricted to rather than the general provision. Counsel started the case of Martin Schroeder and Major Company Nigeria Limited. Counsel maintained that the defendant cannot restrict to section 6.4.2.2, which provides for dismissal in case of prolonged absence for a period of 30 days or more without permission to dismiss the claimant. Counsel also referred to section 5.2.2, page 19, under subhead return to work after sick leave of the defendant's policy and procedures manual to state that the defendant was aware of the claimant's health and therefore the defendant's medical doctor told the CDC that following the review of the X-ray, she refused to issue the claimant's certificate of fitness because the fracture had not healed. Counsel further submitted that the absence from work without medical cover, pursuant to section 5.3.2 of the manual, is non-payment of salary for the period of ill health not covered by medical certificate. Furthermore, the punishment for malingering pursuant to section 6.4.2 is termination. It is the argument of counsel that submission of the defendant that the claimant did not have a letter of approval or medical certificate for his absence from work for 2 to 3 working days is not supported by evidence as Exhibit SU 14 A to K, a medical certificate and reports which supported the claimant's claim that he did not abscond from work, that the claimant was never issued a medical certificate of fitness to resume work because his fracture had not healed. Counsel contended that the claimant has placed before the court his offer of employment, the handbook, which indicates that the punishment meted out on the claimant, assuming but not without conceding that he committed the alleged offenses were excessive, and violated the claimant's contract of employment. So the Constitutional Council that the Defendant Policies and Procedures Manual is binding on the defendant. Council referred the court to the Court of Appeal case of Central Bank of Nigeria and Morris, ESO. The Council maintained that, assuming but without conceding that the claimant abandoned his duties, the claimant was still entitled to his gratuity. Council referred the court to the case of Alaji Liasu Olalere and Olam Nigeria Limited. Judgment delivered on 25th March 2021 by Honorable Justice E.D.E. Esele. In view of the foregoing, to submit that the dismissal of the claimant was excessive when verged against the alleged offenses. Council posted that a reinstatement of the claimant, his employment enjoys statutory flavor. Council started the decision of the Court of Appeal in CBN and Archibon and argued that the Archibon's case is distinguishable from the instance suit. That in the above cited case, the attention of the appellate court was never drawn to the fact that the staff handbook was a subsidiary legislation of the CBN pursuant to Section 51 of the Central Bank Act, which provides that the board shall have powers to make and alter rules and regulations for the good order and management of the bank. Council started the case of Osede Banem Warrior and UBN, judgment of which was delivered on 11th May 2020 by Honorable Justice Weneka, where it was held that the bylaws made by the CBN are legally binding. The submission of counsel that the CBN manual is a CBN bylaw pursuant to Section 51 of the CBN Act. Counsel started the case of Ogoja and Access Bank PLC. That in view of the above, counsel urged the court to hold that the claimant's employment enjoys statutory flavor, and should the court find that his termination was unlawful, it should order the statement of the claimant. However, should the court refuse to order the claimant's reinstatement, counsel urged the court to grant the claimant's alternative relief for the payment of his terminal benefits pursuant to Section 14.3 and 16.32 of the manual. The counsel submitted that the claim for payment of the claimant's productivity allowances for 2017, lunch allowance, and medical expenses, the deposition was never controverted by the defendant, whose response was feeble and evasive. Counsel urged the court to grant the claimant's reliefs, case and 1, for the claim for award of damages and compensation. Counsel refer the court to Section 19D of the NICA, which empowers the court to make an award of compensation or damages in any matter that the court has jurisdiction. Counsel also refer the court to the case of Vivian Chinedu and Diamond Bank, judgment of which was delivered on 12 July 2018 by Honorable Justice Dele Peters, and the case of Sahara Energy Resources and Olawumi Oebola. For the relief for cost, counsel rely on the case of Aluminum Manufacturing Company and Volkswagen, and finally urged the court to grant the reliefs of the claimant, as the dismissal of the claimant was high-handed and excessive. Defendant's reply on points of law. Defendant filed its reply address on 21st March 2020 and argued that the entirety of Section 5.3.1 must be considered and not just parts of it. Counsel referred to the case of Clinton Ventures and Microfinance Bank Limited. Counsel also argued that the claimant was responsible for ensuring that his sick leave was extended after the initial 2 weeks period, although without considering that the defendant was responsible for facilitating the sick leave extension. The same does not have any relevance to this case. That the claim relates to the claimant's dismissal from the defendant because of his absence from office for two 2 to 3 working days without approval, as shown in the report of the defendant's Central Disciplinary Committee. It is the further argument of counsel that it can be gleaned from the application for sick leave that it can be gleaned that application for sick leave is a process, and for a staff of the defendant to be deemed on sick leave, the process must be completed. It's clear that the steps required for the claimant to be validly granted sick leave for an extended period were not followed. Therefore, it cannot be correctly argued that the claimant was on sick leave. That where a document lays a particular procedure for carrying out an act, only that procedure can be used, carry out, and no other. Carry it out and no other. It is a submission of counsel that apart from the initial sick leave certificate covering 2 weeks, none of the medical reports presented by the claimant can justify the claimant's absence from work for 2 to 3 working days for a number of reasons. Firstly, only the medical certificate issued by the bank's hospital is valid. Certificate issued by other hospitals are valid if they meet 2 conditions. The staff member is receiving treatment as an inpatient, and the staff is referred to that hospital by the dependent doctor or by the standby hospitals. And neither of these conditions is met in the instance case. That the claimant was neither an inpatient nor is he referred to the herbal bond setup by the dependent hospital. The second reason that his absence is unjustified is that certificate has to be produced weekly for the duration of the sickness. Counsel referred to section 5.3.2 of the manual that it is clear from the available evidence before the court that this was not done. Counsel submitted that having established that aside from the initial 2 weeks, the claimant presented no medical certificates to cover the entire period of his absence, it is clear that the claimant was absent from work for a period of 30 days without permission sought and obtained, and as such was liable under section 6.4.2.2 of the manual. It also contains one set of facts can give rise to multiple heads of misconduct. The defendant has the discretion to determine which heads of the misconduct to pursue, referring to the case of Ibrahim and Osman. It's a condition of counsel that the manual is not a subsidiary legislation for all intents and purposes, that the manual was not made pursuant to section 51 of the CBN Act. It did not make reference to that section or any other section of the CBN Act or any law whatsoever as the enabling law. Counsel referred to the case of Controller General of Customs and Gusau, that policy documents, commonly referred to as guidelines, are not subsidiary legislations. Counsel therefore urged the court to hold that the manual, to hold that HRPPM is a manual and not a subsidiary legislation. Counsel referred to the case of Adedeji and CBN, where Supreme Court commented on the status of the manual made by the Board of the Central Bank of Nigeria. It's a contention of counsel that the manual is not a subsidiary legislation. Consequently, the employment of the claimant does not enjoy statutory flavor. Counsel further contended that the nature of the claimant's employment is a master-servant relationship. Therefore, the court would not grant an order for reinstatement in a master-servant relationship, even if it held that the dismissal was wrongful, because it will amount to forcing a willing servant on an unwilling master. Counsel started the case of Bako and British Council, Nigeria. Decision of court. Upon careful perusal of the pleadings filed by the parties, the evidence adduced, and submissions of the respective counsel, I observed that while the defendant formulated one issue for determination, but the claimant formulated 2 issues. However, I have chosen to decide this case on the basis of the issue for determination as submitted by the defendant to it. My court, Whether having regard to the evidence laid at the trial, the claimant has made out a case to be entitled to relief sought against the defendant in this suit, unquote. As earlier stated, the claimant's position is that he was involved in a motor accident on 5th of January 2017, where he sustained injury and the defendant gave him 2 weeks leave. But upon reporting for duty on February 2018, claimant said the department instructed the management not to record his attendance. As he was given a query and later invited to the Central Disciplinary Committee on alleged prolonged absence from work and eventually dismissed. It is a contention of the claimant that his dismissal was a contractual breach, given the defendant was fully aware his extended absence was injury-related, that the absence from work without medical cover, pursuant to section 5.3.2 of the manual, is non-payment of salary for the period of ill health not covered by a sick certificate, and that the punishment for malingering pursuant to section 6.4.2 is termination. Let me reproduce the relief sought by the claimant as set out in his statement of facts against the defendants as follows. Number A, a declaration that dismissal of the claimant is without due process and unlawful. Number B, a declaration that non-payment of the claimant's lunch allowances is wrongful and unlawful. Number C, a declaration that the defendant is in arrears of the claimant's salaries for the dates of from the date of dismissal till the date of judgment. Number D, a declaration that the defendant is in arrears of the claimant's productivity allowances for 2017 and other productivity allowances from the date of dismissal till the date of judgment. Number E, a declaration that the employment of the claimant is unbroken and subsisting. Number 8, a declaration that the claimant is entitled to his salaries, productivity allowance of 2017, and other allowances from the date of the purported dismissal to date of reinstatement. Number G, an order of this honorable court for the reinstatement of the claimant to his employment, or in the alternative, an order of this honorable court for the payment of the claimant's terminal benefits, end of year benefits, pursuant to paragraph 14.3 and 16 of the manual and his contract of employment. Number 8, an order of this honorable court for the payment of the claimant's productivity allowance for 2017 and lunch allowances withheld unlawfully by the defendant. Number I, an order of this honorable court for the payment of medical expenses incurred by the claimant and for payment of his health insurance claims as appropriate to his grade. Number J, an order of this honorable court for the payment of damages of 1 billion naira for the mental torture and unfair labor practice meted out to the claimant pursuant to section 19 of the National Industrial Court Act. Number K, an order of this honorable court for the payment of the cost of litigation in the sum of 1 million naira. And for such consequential orders, this honorable court may deem fit to make in the circumstance. On court, looking at the relief sought by the claimant, it is imperative to ascertain the nature of the employment before the parties. In practice, 3 categories of employment have been enumerated by the courts. See the case of Federal Medical Center Ado-Ekiti and Michael, NIA and Anyamfalu, Olania and Unilag, Chitabe and FPSC. Therefore, ascertaining the nature of employment between the parties will definitely determine the order which the court can make, where dismissal turns out to be unlawful or wrongful as the case may be. Whether or not the claimant's employment is one that is clothed with the 3 label, I take into cognizance the fact that the defendant is a creation of statute, as rightly argued by the claimant's counsel. The defendant established under section 1 of the Central Bank of Nigeria Act. And employment is sought to be clothed with statutory flavor when such employment is protected by statute or laid down regulations made to govern the procedure for employment and discipline of an employee. See the case of CBN and Uguilo. The defendant is a creation of statute, and its operations are regulated by the acts that establishes it. That is Central Bank Act 2007. Section 14.2.4 of the said act provides thus, and I quote, appointment of employees of the bank shall only be in respect of positions created by the bank and on such terms and conditions as may be laid down by the board, provided that the appointment and removal of staff of the grade of assistant director and above shall be with the approval of the board. Meanwhile, Section 51 provides thus, the board shall have power to make and alter rules and regulations for the good order and management of the bank, unquote. A careful reading of the above provision of the CBN Act and the provisions in the Human Resources Policies and Procedure Manual put beyond doubt that the employment of the claimant is one that is truly flavored. I so find and hold, because in Benin Electricity Distribution Company and Ese Aluka held that, and I quote, there's no doubt that there is a vast difference between an employment with statutory flavor, in which case the terms of employment of that staff is governed by the statute creating that organization, and any infraction of the terms of employment and discipline as guaranteed by the statute is bound to be declared null and void. That is illegal dismissal, where it occurs. In such situations, the employee is restored to the position as if no disciplinary measures had been taken at all. See the case of Dr. Tao Olorotumba and Professor Shuaibu Abdulrahim, Bamboy and University of Ilorin. However, where the relationship is not governed by statute and there is infraction of the terms of employment and dismissal by the employer, such infraction is merely wrongful and not null and void. The employee can only claim damages for breach of contract and cannot claim arrears of salaries and reinstatement. See the case of Eze and Springbank. Having established the employment relationship of the parties, it is imperative to state that the burden of proof rests on the claimant to establish how his dismissal from the employment of the defendant was a contract breach and unlawful. In this regard, the court in the case of Borishadi and Nigerian Bank of Nigeria held that it is an elementary principle of the rules of litigation that the plaintiff who alleges unlawful dismissal of his employment must prove that the dismissal was unlawful. See the case of Mba Ede and Okufu. In addition to the foregoing, and in view of the declaration sought by the claimant in relation to his dismissal, the court in the case of Diamond Bank and Yahya held thus, and I quote, the law is settled that the courts do not grant the declaratory reliefs based on the admission of the defendant. The plaintiff must satisfy the court by according credible and convincing evidence called by him that he is entitled to the regulatory reliefs. So where the plaintiff on his own evidence fails to prove his claim for declaration, his claim must fail. See the case of Anyaru and Mandilas, Indayako and Anto. Both parties are ad idem that the relationship is regulated by the reviewed human resources policies and procedure manual of the defendant. That is exhibits SU3, and CBN1. The duty of the court in determining the rights and obligations of the parties is to ensure compliance with the terms and conditions of employment. The court in determining the issue framed in the instance suit is equally to ensure that the procedure laid down in the statute establishing the defendant and the defendant human resources policy and procedures manual are complied with. The case of Controller General of Customs and Gusau and Fakode and UAU Teaching Hospital are instructive. It must also be pointed out here, as held in the case of CBN and Archibald, that in interpreting the provisions of the written contract, no addition thereto or subtraction therefrom is permissible. The words used must be given effect to, and no word should be imputed in the interpretation of the intention of the parties. Otherwise, the court would be seen as writing the agreement between the parties. See also the case of Bookshop House Limited and Stanley Consulting Nigeria Limited. It is settled that before an employer can dismiss or terminate the employment of his employee for misconduct, the requirement of fair hearing must be strictly adhered to. It is by giving an opportunity to a person whose rights and obligations may be affected to make representation to the administering authority before that authority makes decision affecting that person. It is a vital prerequisite. A breach of same goes to the root of the investigation and thus will be declared a nullity by the court. See the case of Falai and Dada. This is equally founded on the twin pillars of natural justice rooted in the maxims or the ultra pattern and nemo judex in causa sua. It means the affected person is given enough time to present his defense to any allegation made against him. It means in simplest term an opportunity to be heard. See the case of Ekezo and Union Bank of Nigeria. It is strict law that where an employee is accused of misconduct, the employer must acquaint him of the allegation by issuing him a written notice or query, setting the grounds of the misconduct against him, give him a chance to defend himself, and invite him to make an appropriate representation or defend thereto. Be given an opportunity to cross-examine his accusers, if any, and be allowed to call any witnesses, if any. See the case of Benin Electricity Distribution Company and Esia Aluka. Going by the defendant human resources manual, there are some laid-down procedures that must be followed for dismissal of an employee on ground of misconduct. I hereunder captured the pertinent clauses of the reviewed human resources policies and manual thus, and I quote, Section 6.4.3 states, no disciplinary action shall be taken against an employee without an investigation to establish the facts in the course of which the employee shall always be given a fair hearing. Section 6.5 also provides thus, disciplinary committee, that the bank recognizes the need for thorough investigations to be carried out for disciplinary cases concerning its employees. Consequently, disciplinary committees shall be set up in all locations of the bank to handle disciplinary cases referred to it, in addition to the Central Disciplinary Committee. These committees are: number one, Central Disciplinary Committee, Branch Disciplinary Committee, Central Disciplinary Committee, Departmental Disciplinary Committee. Central Disciplinary Committee has the power to adjudicate on any matter affecting employee discipline that may be referred to it by management. Disciplinary Committee procedure. Query. In all cases, disciplinary committee shall allow the employee against whom an allegation is made to defend himself. The employee shall be issued a query. setting out in clear terms the charges against him, and be requested to answer the query within 3 working days of receipt. Failure to reply the query within 3 working days of receipt shall be deemed as an act of insubordination, which shall be treated accordingly. Proceedings or receipt of the response to the query, or the expiration of 3 working days from the date of receipt of the query by the employee, the committee shall commence sitting after duly informing the employee. On arraignment before the committee, the charges against him shall be read by the chairman, and the employee shall be asked to make his plea. Before his plea is taken, the fact of the case shall be explained to him. If the employee pleads guilty, the committee shall recommend to the departmental director or director HR the appropriate disciplinary measure to be taken against the employee. While the employee makes a plea of not guilty, he shall be given the facility to invite his witnesses or tender documents, if any, and also to cross-examine opposing witnesses. The employee shall, however, not use any of these facilities to delay the proceedings or reasonable appeals. If an employee is not satisfied with the decision of the disciplinary committee, he may appeal to the Director of Human Resources, the DR, or the governor, as the case may be. The above captured disciplinary procedure is in tandem with the general position of the law on discipline of an employee. It is noteworthy that the major procedure to be followed by the defendant before dismissal of the claimant on the allegation of misconduct is the issuance of query to the employee, clearly stating the allegation therein and eliciting an answer from him, affording an opportunity to make presentation in person on the matter to the committee. He shall be allowed to cross-examine witnesses if any. He also has a right to appeal the decision of the defendant. As reiterated, the procedure initiated above is to ensure fair hearing in disciplinary procedure of this defendant's staff. There is no dispute between the parties that the claimant was a staff of the defendant, employed on the 16th of August 1990 as a senior clerk, arose through the ranks to the position of a senior manager before his alleged unlawful dismissal from employment by the defendant. The Employee Relationship Office, Human Resources Department, issued him a query dated 5th March 2018, requiring his explanation in writing of failing or neglecting to report back to duty after the cancellation of transfer and instruction to remain at the Currency Operations Department, Lagos. And on 8th March 2018, he was served a letter of indefinite suspension. On 18th March 2018, he was given another query on alleged possession of daily staff position of Currency Operations Department, dated 10th February 2017, without authority, and giving same document to one Festus Oga, a non-staff of CBN, but a junior brother to the claimant. It is evident that the claimant replied to the query on 20th April 2018, which is Exhibit 12. The defendant then invited the claimant by a letter dated 11th April 2018 to appear before the Central Disciplinary Committee to defend himself, stating that he was free to tender any document or invite any witness that could assist the committee in arriving at a fair decision. The claimant appeared before the Central Disciplinary Committee in Lagos from 17th to 20th April 2018. Thereafter, the defendant dismissed him from his service by letter dated 17th September 2018. However, the claimant has complained that the dismissal is unlawful. It's clear that the claimant admitted that he was queried and he responded to same. He also admitted that he appeared before the disciplinary committee and presented his case before he was dismissed. By his admission, it appeared that the claimant was heard. It is settled law that fair hearing is satisfied when once a party has been given the opportunity to be heard respect of any matter or cause touching on or affecting his interests. See the case of INEC and Musa, the Supreme Court in the case of Immunike and Unity Bank has held that where an employer accuses an employee of misconduct by way of a query, and the employee answers the query before the employer takes a decision of the employee's appointment, thus satisfy the requirement of fair hearing. In this regard, I find that the claimant was given fair hearing. Once an employee was confronted with allegations of misconduct or infraction before his employment was terminated, he cannot complain about lack of fair hearing. See the case of Joseph and First Inland Bank Limited, Udo and CSC, Akwa Ibom State. The Central Disciplinary Committee at pages 73 to 74 made the following conclusion and recommendations. And I quote, on the first allegation, Mr. Ume did not admit the allegation. The committee, however, found him liable on the allegation because he ought to have reported for duty in the absence of a valid sick leave certificate. More so, Chapter 5, Section 5 of the Human Resources Policy and Procedure Manual states that except where a member of staff is away for a single day, absences claimed as sick leave must be covered by a medical certificate. On the second allegation, Mr. Ume did not admit the allegation. The committee, however, found him liable on the allegation because though he notified the bank of his medical condition, he failed to submit medical certificate to cover the period he was absent in line with the policy of the bank. Section 5 of the Human Resources Policy and Procedures Manual provides inter alia that sick leave certificate from health centers, teaching and general hospitals, and other medical institutions will be accepted only when the staff member is actually receiving treatment from such hospitals as inpatient, that is, on admission, and when he or she has been referred to such hospitals or centers by the bank's doctors or the standby hospital. Such certificates must be produced within 24 hours of the admission of the staff into the health establishment. While the staff is being treated in isolation without a bank doctor, certificate must be produced within 3 days of hospitalization and thereafter, weekly, for the duration of the sickness. The staff is responsible for drawing the attention of the hospital to this requirement. On court, although Mr. Ume claimed to have been treated by a medical bond setter, he was never an inpatient, and none of the letters purportedly from the bond setters admitted otherwise. He failed / refused to forward the sick leave certificate throughout the duration of his absence. The committee was therefore convinced that Mr. Ume was absent from duty without permission from 13 February 2017 to 5 February 2018. And the sanctions as stipulated in Chapter 6, Section 1, Subsection 2 of the Human Resources Policy and Procedure Manuals is dismissal from the bank's service. Recommendation. In view of the above, the committee recommends that Mr. Ume Simon, Senior Manager, be dismissed from the bank service on the first query. On court, to the claimant's contention that Section 6.4.2 of Exhibit 3 provides for termination of appointment in case of malingering and the penalty for non-prohibition of medical certificate to cover a period of illness pursuant to Section 5.3 of the handbook is non-payment of salary. It's non-payment of salary for the period of ill health not covered by a sick leave certificate. While it is Section 6.4 that provides for dismissal in case of prolonged absence, absconding for a period of 30 days or more without permission, that the claimant dismissal was excessive of the prescribed punishment and therefore unlawful. However, when dealing with a case of an unlawful dismissal of an employee or the exercise by a government officer of his powers to the detriment of a student, the court is only concerned with whether the employer followed the right procedure as laid down by the conditions of service or the act under which it acted, including the observance of the rules of natural justice. See the case of NEPA and El Fandi, section 5.3.2.2 of Exhibit 3 says that sick leave certificate will be accepted only when the staff member is actually receiving treatment on admission and when he has been referred to such hospital by the bank doctors or the standby hospitals. It also goes to state that such certificates must be produced within 24 hours of the admission of the staff into the health establishment. While the staff is being treated in a location without a bank doctor, certificate must be produced within 3 days of hospitalization and thereafter weekly for the duration of the sickness. The staff is responsible for drawing the attention of the hospital to this requirement, that the salary may not be paid for absence from duty on the ground of ill health not covered by the procedure laid down above, and the bank may also not be responsible for the medical expenses incurred. See section 5.3.2 of Exhibit 3 and Exhibit CBN 1. It can therefore be seen from the above that the claimant was not on admission, and by Exhibit 17, he even declined surgery, stating that he had commenced traditional bone setting treatment. The claimant did not prove by the medical certificate he presented that he was an inpatient and did not as well prove that the requirements under section 5.3.2 have been satisfied. The medical evidence did not cover the period the claimant was absent from work in line with the defendant's manual. It's my finding, therefore, that the decision of the defendant in dismissing the claimant for prolonged absence from duty without permission under section 6.4 of Exhibit CBN 1 cannot be faulted. Thus legal, as it complies with the defendant's policies and procedures manual and the rules of natural justice. I so find and hold. I'm satisfied that the defendant has justified the reasons it dismissed the claimant. Consequently, the declaration sought in relief A must fail. The declaration having failed, the ancillary orders in relief C, E, and G also fail, having no legs to stand on their own. See the case of Ngogu and Atuma. Reliefs B, D, H, and F are for the payment of loans and productivity allowances for 2017 till judgment. However, productivity allowance, as contended by the defendant, is performance-driven, and the entitlement of a staff to those allowances will only depend on whether they have been proved. There are special damages which have not been specifically pleaded and strictly proved by the claimant. Therefore, this relief also failed. The claimant alternative is by the second leave of his relief G, seeking for the payment of the claimant's terminal benefit pursuant to section 14.3 and 16.23 of the Human Resources Manual and his contract of employment. However, these sections apply to members of staff who may be considered an invalid if for health reasons or any other accepted reason a properly constituted medical board finds him to be permanently incapable of performing his normal duties. The claimant was never considered an invalid under section 14.3, and the claimant did not resign, die in service, or retire from the defendant to be entitled to the end of service benefit, as contemplated under section 16.3 of Exhibit 3. This relief also fails. Relief I is for the payment of the medical expenses incurred by the claimant and for payment of his health insurance claims as, as appropriate to his health. As appropriate to his health, having not met the conditions as stated in section 5.3.2 of Exhibit 3 and the findings in paragraph 17 of Exhibit CBN 2, this relief accordingly fails. The claimant claims for compensation and cost of action are also declined and refused since the main claim has failed. All said, claimant's case fails in its entirety as he has not been able to prove his case on the balance of probability. Accordingly, all the relief sought fail and the issue formulated for termination is resolved in favor of the defendant against the claimant. Consequently, the claimant's case is hereby dismissed.
Yes. My Lord, we are most grateful for the well-considered judgment.
Thank you, my Lord, for the judgment.
Thank you, Stephanie.
Well done, my Lord.
Aja, well done, thank you. We send the file, Aja, to you. And the copies of the judgments for transmission. So, ladies and gentlemen, Aja, in the absence of any other thing.
Nothing again, my Lord.
Okay, so I
Can take our leave.
yes, I will rise.
Oh.
I wish you good afternoon. Thank you.
All right, my Lord. Wish my Lord a wonderful
Thank you, my
Christmas.
Lord.
Thank you,
Thank you, my Lord.
Stephanie. Thank you. Thank you.